Council of Europe Convention on Laundering, Search, Seizure and Confiscation of the Proceeds from Crime and on the Financing of Terrorism, signed in Warsaw on 16 May 2005, entry into force, in accordance with Article 49 of the Convention European Treaty Series, ETS, number 198, Depositary, Secretary-General of the Council of Europe. Preamble. The Member States of the Council of Europe and the other signatories hereto. Considering that the aim of the Council of Europe is to achieve a greater unity between its members. Convinced of the need to pursue a common criminal policy aimed at the protection of society. Considering that the fight against serious crime, which has become an increasingly international problem, calls for the use of modern and effective methods on an international scale. Believing that one of these methods consists in depriving criminals of the proceeds from crime and instrumentalities. Considering that for the attainment of this aim a well-functioning system of international cooperation also must be established. Bearing in mind the Council of Europe Convention on Laundering, Search, Seizure and Confiscation of the Proceeds from Crime, ETS number 141A hereinafter referred to as the 1990 Convention. Recalling also Resolution 1373/2001 on threats to international peace and security caused by terrorist acts adopted by the Security Council of the United Nations on 28 September 2001, and particularly its paragraph 3d. Recalling the International Convention for the Suppression of the Financing of Terrorism, adopted by the General Assembly of the United Nations on 9 December 1999 and particularly its Articles 2 and 4, which oblige states parties to establish the financing of terrorism as a criminal offense. Convinced of the necessity to take immediate steps to ratify and to implement fully the International Convention for the Suppression of the Financing of Terrorism, cited above, have agreed as follows. Chapter 1. Use of terms. Article 1. Use of terms. For the purposes of this convention. A. Proceeds means any economic advantage, derived from or obtained, directly or indirectly, from criminal offenses. It may consist of any property as defined in subparagraph B of this article. B. Property includes property of any description, whether corporeal or incorporeal, movable or removable, and legal documents or instruments evidencing title to or interest in such property. C. Instrumentalities means any property used or intended to be used, in any manner, wholly or in part, to commit a criminal offense or criminal offenses. D. Confiscation means a penalty or a measure, ordered by a court following proceedings in relation to a criminal offense or criminal offenses resulting in the final deprivation of property. E. Predicate offense means any criminal offense as a result of which proceeds were generated that may become the subject of an offense as defined in Article 9 of this convention. F. Financial Intelligence Unit, hereinafter referred to as FU, means a central, national agency responsible for receiving, and, as permitted, requesting, analyzing and disseminating to the competent authorities. Disclosures of financial information. I. Concerning suspected proceeds and potential financing of terrorism, or 2. Required by national legislation or regulation. In order to combat money laundering and financing of terrorism. G. Freezing or seizure means temporarily prohibiting the transfer, destruction, conversion, disposition or movement of property or temporarily assuming custody or control of property on the basis of an order issued by a court or other competent authority. H. Financing of terrorism means the acts set out in Article 2 of the International Convention for the Suppression of the Financing of Terrorism, cited above. Chapter 2. Financing of Terrorism. Article 2. Application of the Convention to the Financing of Terrorism. 1. Each party shall adopt such legislative and other measures as may be necessary to enable it to apply the provisions contained in Chapters 3, 4 and V of this Convention to the financing of terrorism. 2. In particular, each party shall ensure that it is able to search, trace, identify, freeze, seize and confiscate property, of illicit or illicit origin, used or allocated to be used by any means, in whole or in part, for the financing of terrorism, or the proceeds of this offense, and to provide cooperation to this end to the widest possible extent. Chapter 3. Measures to be taken at national level, Section 1. General Provisions, Article 3, Confiscation Measures, 1. Each party shall adopt such legislative and other measures as may be necessary to enable it to confiscate instrumentalities and proceeds or property the value of which corresponds to such proceeds and laundered property. 2. Provided that paragraph 1 of this article applies to money laundering and to the categories of offences in the appendix to the Convention, each party may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, by a declaration addressed to the Secretary-General of the Council of Europe, declare that paragraph 1 of this article applies. A. Only insofar as the offence is punishable by deprivation of liberty or a detention order for a maximum of more than 1 year. However, each party may make a declaration on this provision in respect of the confiscation of the proceeds from tax offences for the sole purpose of being able to confiscate such proceeds, both nationally and through international cooperation, under national and international tax and debt recovery legislation and/or b. Only to a list of specified offences. 3. Parties may provide for mandatory confiscation in respect of offences which are subject to the confiscation regime. Parties may, in particular, include in this provision the offences of money laundering, drug trafficking, trafficking in human beings and any other serious offence. 4. Each party shall adopt such legislative or other measures as may be necessary to require that, in respect of a serious offence or offences as defined by national law, an offender demonstrates the origin of alleged proceeds or other property liable to confiscation to the extent that such a requirement is consistent with the principles of its domestic law. Article 4. Investigative and provisional measures. Each party shall adopt such legislative and other measures as may be necessary to enable it to identify, trace, freeze or seize rapidly property which is liable to confiscation pursuant to Article 3, in order in particular to facilitate the enforcement of a later confiscation. Article 5. Freezing, seizure and confiscation. Each party shall adopt such legislative and other measures as may be necessary to ensure that the measures to freeze, seize and confiscate also encompass a. The property into which the proceeds have been transformed or converted. b. Property acquired from legitimate sources, if proceeds have been intermingled, in whole or in part, with such property, up to the assessed value of the intermingled proceeds. c. Income or other benefits derived from proceeds, from property into which proceeds of crime have been transformed or converted or from property with which proceeds of crime have been intermingled, up to the assessed value of the intermingled proceeds, in the same manner and to the same extent as proceeds. Article 6. Management of frozen or seized property. Each party shall adopt such legislative or other measures as may be necessary to ensure proper management of frozen or seized property in accordance with Articles 4 and 5 of this Convention. Article 7. Investigative powers and techniques. 1. Each party shall adopt such legislative and other measures as may be necessary to empower its courts or other competent authorities to order that bank, financial or commercial records be made available or be seized in order to carry out the actions referred to in Articles 3, 4 and 5. A party shall not decline to act under the provisions of this article on grounds of bank secrecy. 2. Without prejudice to paragraph 1, Each party shall adopt such legislative and other measures as may be necessary to enable it to a. Determine whether a natural or legal person is a holder or beneficial owner of one or more accounts, of whatever nature, in any bank located in its territory and, if so, obtain all of the details of the identified accounts. b. Obtain the particulars of specified bank accounts and of banking operations which have been carried out during a specified period through one or more specified accounts, including the particulars of any sending or recipient account. c. Monitor, during a specified period, the banking operations that are being carried out through one or more identified accounts and d. Ensure that banks do not disclose to the bank customer concerned or to other third persons that information has been sought or obtained in accordance with subparagraphs A, B, or C, or that an investigation is being carried out. Parties shall consider extending this provision to accounts held in non-bank financial institutions. 3. Each party shall consider adopting such legislative and other measures as may be necessary to enable it to use special investigative techniques facilitating the identification and tracing of proceeds and the gathering of evidence related thereto, such as observation, interception of telecommunications, access to computer systems in order to produce specific documents. Article 8, Legal Remedies. Each party shall adopt such legislative and other measures as may be necessary to ensure that interested parties affected by measures UNIDER Articles 3, 4 and 5 and such other provisions in this section as are relevant, shall have effective legal remedies in order to preserve their rights. Article 9, Laundering Offences. 1. Each party shall adopt such legislative and other measures as may be necessary to establish as offences under its domestic law, when committed intentionally. A. The conversion or transfer of property, knowing that such property is proceeds, for the purpose of concealing or disguising the illicit origin of the property or of assisting any person who is involved in the commission of the predicate offence to evade the legal consequences of his actions. B. The concealment or disguise of the true nature, source, location, disposition, movement, rights with respect to, or ownership of, property, knowing that such property is proceeds, and, subject to its constitutional principles and the basic concepts of its legal system. C. The acquisition, possession or use of property, knowing, at the time of receipt, that such property was proceeds. D. Participation in, association or conspiracy to commit, attempts to commit and aiding, abetting, facilitating and counseling the commission of any of the offences established in accordance with this article. 2. For the purposes of implementing or applying paragraph 1 of this article, A. It shall not matter whether the predicate offence was subject to the criminal jurisdiction of the party. B. It may be provided that the offences set forth in that paragraph do not apply to the persons who committed the predicate offence. C. Knowledge, intent or purpose required as an element of an offence set forth in that paragraph may be inferred from objective, factual circumstances. 3. Each party may adopt such legislative and other measures as may be necessary to establish as an offence under its domestic law all or some of the acts referred to in paragraph 1 of this article, in either or both of the following cases where the offender A. Suspected that the property was proceeds. B. Ought to have assumed that the property was proceeds. 4. Provided that paragraph 1 of this article applies to the categories of predicate offences in the appendix to the Convention, each state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, by a declaration addressed to the Secretary-General of the Council of Europe, declare that paragraph 1 of this article applies. A. Only insofar as the predicate offence is punishable by deprivation of liberty or a detention order for a maximum of more than 1 year, or for those parties that have a minimum threshold for offences in their legal system, insofar as the offense is punishable by deprivation of liberty or a detention order for a minimum of more than 6 months and/or b. only to a list of specified predicate offenses and/or c. to a category of serious offenses in the national law of the party. 5. Each party shall ensure that a prior or simultaneous conviction for the predicate offense is not a prerequisite for a conviction for money laundering. 6. Each party shall ensure that a conviction for money laundering under this article is possible where it is proved that the property, the object of paragraph 1(a) or (b) of this article, originated from a predicate offense, without it being necessary to establish precisely which offense. 7. Each party shall ensure that predicate offenses for money laundering extend to conduct that occurred in another state, which constitutes an offense in that state, and which would have constituted a predicate offense had it occurred domestically. Each party may provide that the only prerequisite is that the conduct could have constituted a predicate offense had it occurred domestically. Article 10, Corporate Liability. 1. Each party shall adopt such legislative and other measures as may be necessary to ensure that legal persons can be held liable for the criminal offences of money laundering established in accordance with this convention, committed for their benefit by any natural person, acting either individually or as part of an organ of the legal person, who has a leading position within the legal person, based on a power of representation of the legal person or b. an authority to take decisions on behalf of the legal person, or c. an authority to exercise control within the legal person, as well as for involvement of such a natural person as accessory or instigator in the above-mentioned offences. 2. Apart from the cases already provided for in paragraph 1, each party shall take the necessary measures to ensure that a legal person can be held liable where the lack of supervision or control by a natural person referred to in paragraph 1 has made possible the commission of the criminal offences mentioned in paragraph 1 for the benefit of that legal person by a natural person under its authority. 3. Liability of a legal person under this article shall not exclude criminal proceedings against natural persons who are perpetrators, instigators of, or accessories to, the criminal offences mentioned in paragraph 1. 4. Each party shall ensure that legal persons held liable in accordance with this article, shall be subject to effective, proportionate and dissuasive criminal or non-criminal sanctions, including monetary sanctions. Article 11. Previous decisions. Each party shall adopt such legislative and other measures as may be necessary to provide for the possibility of taking into account, when determining the penalty, final decisions against a natural or legal person taken in another party in relation to offences established in accordance with this convention. Section 2. Financial Intelligence Unit, FU, and Prevention. Article 12. Financial Intelligence Unit, FU. 1. Each party shall adopt such legislative and other measures as may be necessary to establish an FU as defined in this convention. 2. Each party shall adopt such legislative and other measures as may be necessary to ensure that its FU has access, directly or indirectly, on a timely basis to the financial, administrative and law enforcement information that it requires to properly undertake its functions, including the analysis of suspicious transaction reports. Article 13. Measures to prevent money laundering. 1. Each party shall adopt such legislative and other measures as may be necessary to institute a comprehensive domestic regulatory and supervisory or monitoring regime to prevent money laundering and shall take due account of applicable international standards, including in particular the recommendations adopted by the Financial Action Task Force on Money Laundering, FATF. 2. In that respect, each party shall adopt, in particular, such legislative and other measures as may be necessary to a. Require legal and natural persons which engage in activities which are particularly likely to be used for money laundering purposes, and as far as these activities are concerned, 2. Identify and verify the identity of their customers and, where applicable, their ultimate beneficial owners, and to conduct ongoing due diligence on the business relationship, while taking into account a risk-based approach. 2. Report suspicions on money laundering subject to safeguard. 3. Take supporting measures, such as record keeping on customer identification and transactions, training of personnel and the establishment of internal policies and procedures, and if appropriate, adapted to their size and nature of business. B. Prohibit, as appropriate, the persons referred to in subparagraph A, from disclosing the fact that a suspicious transaction report or related information has been transmitted or that a money laundering investigation is being or may be carried out. C. Ensure that the persons referred to in subparagraph A are subject to effective systems for monitoring, and where applicable supervision, with a view to ensure their compliance with the requirements to combat money laundering, where appropriate on a risk-sensitive basis. 3. In that respect, each party shall adopt such legislative or other measures as may be necessary to detect the significant physical cross-border transportation of cash and appropriate bearer negotiable instruments. Article 14. Postponement of domestic suspicious transactions. Each party shall adopt such legislative and other measures as may be necessary to permit urgent action to be taken by the FU or, as appropriate, by any other competent authorities or body, when there is a suspicion that a transaction is related to money laundering, to suspend or withhold consent to a transaction going ahead in order to analyze the transaction and confirm the suspicion. Each party may restrict such a measure to cases where a suspicious transaction report has been submitted. The maximum duration of any suspension or withholding of consent to a transaction shall be subject to any relevant provisions in national law. Chapter 4. International Cooperation. Section 1. Principles of International Cooperation, Article 15, General Principles and Measures for International Cooperation. 1. The parties shall mutually cooperate with each other to the widest extent possible for the purposes of investigations and proceedings aiming at the confiscation of instrumentalities and proceeds. 2. Each party shall adopt such legislative or other measures as may be necessary to enable it to comply, under the conditions provided for in this chapter, with requests. A. For confiscation of specific items of property representing proceeds or instrumentalities, as well as for confiscation of proceeds consisting in a requirement to pay a sum of money corresponding to the value of proceeds. B. For investigative assistance and provisional measures with a view to either form of confiscation referred to under A, above. 3. Investigative assistance and provisional measures sought in paragraph 2, B, shall be carried out as permitted by and in accordance with the internal law of the requested party. Where the request concerning one of these measures specifies formalities or procedures which are necessary under the law of the requesting party, even if unfamiliar to the requested party, the latter shall comply with such requests to the extent that the action sought is not contrary to the fundamental principles of its law. 4. Each party shall adopt such legislative or other measures as may be necessary to ensure that the requests coming from other parties in order to identify, trace, freeze or seize the proceeds and instrumentalities, receive the same priority as those made in the framework of internal procedures. Section 2. Investigative Assistance. Article 16. Obligation to assist. The parties shall afford each other, upon request, the widest possible measure of assistance in the identification and tracing of instrumentalities, proceeds and other property liable to confiscation. Such assistance shall include any measure providing and securing evidence as to the existence, location or movement, nature, legal status or value of the aforementioned property. Article 17. Requests for information on bank accounts. 1. Each party shall, under the conditions set out in this article, take the measures necessary to determine, in answer to a request sent by another party, whether a natural or legal person that is the subject of a criminal investigation holds or controls one or more accounts, of whatever nature, in any bank located in its territory and, if so, provide the particulars of the identified accounts. 2. The obligation set out in this article shall apply only to the extent that the information is in the possession of the bank keeping the account. 3. In addition to the requirements of Article 37, the requesting party shall, in the request, a. state why it considers that the requested information is likely to be of substantial value for the purpose of the criminal investigation into the offense. b. State on what grounds it presumes that banks in the requested party hold the account and specify, to the widest extent possible, which banks and/or accounts may be involved and c. Include any additional information available which may facilitate the execution of the request. 4. The requested party may make the execution of such a request dependent on the same conditions as it applies in respect of requests for search and seizure. 5. Each state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, by a declaration addressed to the Secretary-General of the Council of Europe, declare that this article applies only to the categories of offences specified in the list contained in the appendix to this convention. 6. Parties may extend this provision to accounts held in non-bank financial institutions. Such extension may be made subject to the principle of reciprocity. Article 18. Requests for information on banking transactions. 1. On request by another party, the requested party shall provide the particulars of specified bank accounts and of banking operations which have been carried out during a specified period through one or more accounts specified in the request, including the particulars of any sending or recipient account. 2. The obligation set out in this article shall apply only to the extent that the information is in the possession of the bank holding the account. 3. In addition to the requirements of Article 37, the requesting party shall in its request indicate why it considers the requested information relevant for the purpose of the criminal investigation into the offense. 4. The requested party may make the execution of such a request dependent on the same conditions as it applies in respect of requests for search and seizure. 5. Parties may extend this provision to accounts held in non-bank financial institutions. Such extension may be made subject to the principle of reciprocity. Article 19. Requests for the monitoring of banking transactions. 1. Each party shall ensure that, at the request of another party, it is able to monitor, during a specified period, the banking operations that are being carried out through one or more accounts specified in the request and communicate the results thereof to the requesting party. 2. In addition to the requirements of Article 37, the requesting party shall in its request indicate why it considers the requested information relevant for the purpose of the criminal investigation into the offense. 3. The decision to monitor shall be taken in each individual case by the competent authorities of the requested party, with due regard from the national law of that party. 4. The practical details regarding the monitoring shall be agreed between the competent authorities of the requesting and requested parties. 5. Parties may extend this provision to accounts held in non-bank financial institutions. Article 20. Spontaneous information without prejudice to its own investigations or proceedings. A party may without prior request forward to another party information on instrumentalities and proceeds, when it considers that the disclosure of such information might assist the receiving party in initiating or carrying out investigations or proceedings or might lead to a request by that party under this chapter. Section 3. Provisional Measures. Article 21. Obligation to take provisional measures. 1. at the request of another party which has instituted criminal proceedings or proceedings for the purpose of confiscation, a party shall take the necessary provisional measures, such as freezing or seizing, to prevent any dealing in, transfer or disposal of property which, at a later stage, may be the subject of a request for confiscation or which might be such as to satisfy the request. 2. A party which has received a request for confiscation pursuant to Article 23 shall, if so requested, take the measures mentioned in paragraph 1 of this article in respect of any property which is the subject of the request or which might be such as to satisfy the request. Article 22. Execution of Provisional Measures. 1. After the execution of the provisional measures requested in conformity with paragraph 1 of Article 21, the requesting party shall provide spontaneously and as soon as possible to the requested party all information which may question or modify the extent of these measures. The requesting party shall also provide without delays all complementary information requested by the requested party and which is necessary for the implementation of and the follow-up to the provisional measures. 2. Before lifting any provisional measure taken pursuant to this article, the requested party shall, wherever possible, give the requesting party an opportunity to present its reasons in favor of continuing the measure. Section 4. Confiscation. Article 23. Obligation to confiscate. 1. A party, which has received a request made by another party for confiscation concerning instrumentalities or proceeds, situated in its territory, shall a. Enforce a confiscation order made by a court of the requesting party in relation to such instrumentalities or proceeds or b. Submit the request to its competent authorities for the purpose of obtaining an order of confiscation, and, if such order is granted, enforce it. 2. For the purposes of applying paragraph 1, b, of this article, any party shall whenever necessary have competence to institute confiscation proceedings under its own law. 3. The provisions of paragraph 1 of this article shall also apply to confiscation consisting in a requirement to pay a sum of money corresponding to the value of proceeds, if property on which the confiscation can be enforced is located in the requested party. In such cases, when enforcing confiscation pursuant to paragraph 1, the requested party shall, if payment is not obtained, realize the claim on any property available for that purpose. 4. If a request for confiscation concerns a specific item of property, the parties may agree that the requested party may enforce the confiscation in the form of a requirement to pay a sum of money corresponding to the value of the property. 5. The parties shall cooperate to the widest extent possible under their domestic law with those parties which request the execution of measures equivalent to confiscation leading to the deprivation of property, which are not criminal sanctions, insofar as such measures are ordered by a judicial authority of the requesting party in relation to a criminal offense, provided that it has been established that the property constitutes proceeds or other property in the meaning of Article 5 of this Convention. Article 24, Execution of Confiscation. 1. The procedures for obtaining and enforcing the confiscation under Article 23 shall be governed by the law of the requested party. 2. The requested party shall be bound by the findings as to the facts insofar as they are stated in a conviction or judicial decision of the requesting party or insofar as such conviction or judicial decision is implicitly based on them. 3. Each state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, by a declaration addressed to the Secretary-General of the Council of Europe, declare that paragraph 2 of this article applies only subject to its constitutional principles and the basic concepts of its legal system. 4. If the confiscation consists in the requirement to pay a sum of money, the competent authority of the requested party shall convert the amount thereof into the currency of that party at the rate of exchange ruling at the time when the decision to enforce the confiscation is taken. 5. In the case of Article 23, Paragraph 1a, the requesting party alone shall have the right to decide on any application for review of the confiscation order. Article 25, Confiscated Property. 1. Property confiscated by a party pursuant to Articles 23 and 24 of this Convention, shall be disposed of by that party in accordance with its domestic law and administrative procedures. 2. When acting on the request made by another party in accordance with Articles 23 and 24 of this Convention, parties shall, to the extent permitted by domestic law and if so requested, give priority consideration to returning the confiscated property to the requesting party so that it can give compensation to the victims of the crime or return such property to their legitimate owners. 3. When acting on the request made by another party in accordance with Articles 23 and 24 of this Convention, a party may give special consideration to concluding agreements or arrangements on sharing with other parties, on a regular or case-by-case basis, such property, in accordance with its domestic law or administrative procedures. Article 26, Right of Enforcement and Maximum Amount of Confiscation. 1. A request for confiscation made under Articles 23 and 24 does not affect the right of the requesting party to enforce itself the confiscation order. 2. Nothing in this Convention shall be so interpreted as to permit the total value of the confiscation to exceed the amount of the sum of money specified in the confiscation order. If a party finds that this might occur, the parties concerned shall enter into consultations to avoid such an effect. Article 27, Imprisonment in Default. The requested party shall not impose imprisonment in default or any other measure restricting the liberty of a person as a result of a request under Article 23, if the requesting party has so specified in the request. Section 5. Refusal and postponement of cooperation. Article 28, Grounds for refusal. 1. Cooperation under this chapter may be refused if a. The action sought would be contrary to the fundamental principles of the legal system of the requested party or b. The execution of the request is likely to prejudice the sovereignty, security, order public or other essential interests of the requested party or c. In the opinion of the requested party, the importance of the case to which the request relates does not justify the taking of the action sought or d. The offense to which the request relates is a fiscal offense, with the exception of the financing of terrorism. E. The offense to which the request relates is a political offense, with the exception of the financing of terrorism or f. The requested party considers that compliance with the action sought would be contrary to the principle of ne bis in idem or g. The offense to which the request relates would not be an offense under the law of the requested party if committed within its jurisdiction. However, this ground for refusal applies to cooperation under Section 2 only insofar as the assistance sought involves coercive action. Where dual criminality is required for cooperation under this chapter, that requirement shall be deemed to be satisfied regardless of whether both parties place the offense within the same category of offenses or denominate the offense by the same terminology, provided that both parties criminalize the conduct underlying the offense. 2. Cooperation under Section 2, insofar as the assistance sought involves coercive action, and under Section 3 of this chapter, may also be refused if the measures sought could not be taken under the domestic law of the requested party for the purposes of investigations or proceedings, had it been a similar domestic case. 3. Where the law of the requested party so requires, cooperation under Section 2, insofar as the assistance sought involves coercive action, and under Section 3 of this chapter may also be refused if the measures sought or any other measures having similar effects would not be permitted under the law of the requesting party, or, as regards the competent authorities of the requesting party, if the request is not authorized by either a judge or another judicial authority, including public prosecutors, any of these authorities acting in relation to criminal offenses. 4. Cooperation under Section 4 of this chapter may also be refused if a. Under the law of the requested party, confiscation is not provided for in respect of the type of offense to which the request relates, or b. Without prejudice to the obligation pursuant to Article 23, Paragraph 3, it would be contrary to the principles of the domestic law of the requested party concerning the limits of confiscation in respect of the relationship between an offense and I. An economic advantage that might be qualified as its proceeds, or 2. Property that might be qualified as its instrumentalities, or c. Under the law of the requested party, confiscation may no longer be imposed or enforced because of the lapse of time, or d. Without prejudice to Article 23, Paragraph 5, the request does not relate to a previous conviction, or a decision of a judicial nature, or a statement in such a decision that an offense or several offenses have been committed, on the basis of which the confiscation has been ordered or is sought, or e. Confiscation is either not enforceable in the requesting party, or it is still subject to ordinary means of appeal, or f. The request relates to a confiscation order resulting from a decision rendered in absentia of the person against whom the order was issued, and, in the opinion of the requested party, the proceedings conducted by the requesting party leading to such decision did not satisfy the minimum rights of defense recognized as due to everyone against whom a criminal charge is made. 5. For the purpose of Paragraph 4, f. of this article, a decision is not considered to have been rendered in absentia if a. It has been confirmed or pronounced after opposition by the person concerned, or b. It has been rendered on appeal, provided that the appeal was lodged by the person concerned. 6. When considering, for the purposes of Paragraph 4, f. of this article, if the minimum rights of defense have been satisfied, the requested party shall take into account the fact that the person concerned has deliberately sought to evade justice, or the fact that that person, having had the possibility of lodging a legal remedy against the decision made in absentia, elected not to do so. The same will apply when the person concerned, having been duly served with the summons to appear, elected not to do so nor to ask for adjournment. 7. A party shall not invoke bank secrecy as a ground to refuse any cooperation under this chapter. Where its domestic law so requires, a party may require that a request for cooperation which would involve the lifting of bank secrecy be authorized by either a judge or another judicial authority, including public prosecutors, any of these authorities acting in relation to criminal offenses. 8. Without prejudice to the ground for refusal provided for in Paragraph 1, a. of this article. a. The fact that the person under investigation or subjected to a confiscation order by the authorities of the requesting party is a legal person shall not be invoked by the requested party as an obstacle to affording any cooperation under this chapter. b. The fact that the natural person against whom an order of confiscation of proceeds has been issued has died, or the fact that a legal person against whom an order of confiscation of proceeds has been issued has subsequently been dissolved shall not be invoked as an obstacle to render assistance in accordance with Article 23, Paragraph 1, a. c. The fact that the person under investigation or subjected to a confiscation order by the authorities of the requesting party is mentioned in the request both as the author of the underlying criminal offense and of the offense of money laundering, in accordance with Article 9.2, b. of this convention, shall not be invoked by the requested party as an obstacle to affording any cooperation under this chapter. Article 29. Postponement. The requested party may postpone action on a request if such action would prejudice investigations or proceedings by its authorities. Article 30. Partial or conditional granting of a request. Before refusing or postponing cooperation under this chapter, the requested party shall, where appropriate after having consulted the requesting party, consider whether the request may be granted partially or subject to such conditions as it deems necessary. Section 6. Notification and protection of third parties' rights. Article 31. Notification of documents. 1. The parties shall afford each other the widest measure of mutual assistance in the serving of judicial documents to persons affected by provisional measures and confiscation. 2. Nothing in this article is intended to interfere with a. The possibility of sending judicial documents, by postal channels, directly to persons abroad. b. The possibility for judicial officers, officials or other competent authorities of the party of origin to effect service of judicial documents directly through the consular authorities of that party or through judicial officers, officials or other competent authorities of the party of destination. Unless the party of destination makes a declaration to the contrary to the Secretary-General of the Council of Europe at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession. 3. When serving judicial documents to persons abroad affected by provisional measures or confiscation orders issued in the sending party, this party shall indicate what legal remedies are available under its law to such persons. Article 32. Recognition of foreign decisions. 1. When dealing with a request for cooperation under Sections 3 and 4, the requested party shall recognize any judicial decision taken in the requesting party regarding rights claimed by third parties. 2. Recognition may be refused if a. Third parties did not have adequate opportunity to assert their rights or b. The decision is incompatible with a decision already taken in the requested party on the same matter or c. It is incompatible with the ordre public of the requested party or d. The decision was taken contrary to provisions on exclusive jurisdiction provided for by the law of the requested party. Section 7. Procedural and other general rules. Article 33. Central Authority. 1. The parties shall designate a central authority or, if necessary, authorities, which shall be responsible for sending and answering requests made under this chapter, the execution of such requests or the transmission of them to the authorities competent for their execution. 2. Each party shall, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, communicate to the Secretary-General of the Council of Europe the names and addresses of the authorities designated in pursuance of paragraph 1 of this article. Article 34. Direct communication. 1. The central authorities shall communicate directly with one another. 2. In the event of urgency, requests or communications under this chapter may be sent directly by the judicial authorities, including public prosecutors, of the requesting party to such authorities of the requested party. In such cases a copy shall be sent at the same time to the central authority of the requested party through the central authority of the requesting party. 3. Any request or communication under paragraphs 1 and 2 of this article may be made through the International Criminal Police Organization, Interpol. 4. Where a request is made pursuant to paragraph 2 of this article and the authority is not competent to deal with the request, it shall refer the request to the competent national authority and inform directly the requesting party that it has done so. 5. Requests or communications under Section 2 of this chapter, which do not involve coercive action, may be directly transmitted by the competent authorities of the requesting party to the competent authorities of the requested party. 6. Draft requests or communications under this chapter may be sent directly by the judicial authorities of the requesting party to such authorities of the requested party prior to a formal request to ensure that it can be dealt with efficiently upon receipt and contain sufficient information and supporting documentation for it to meet the requirements of the legislation of the requested party. Article 35, Form of Request and Languages. 1. All requests under this chapter shall be made in writing. They may be transmitted electronically, or by any other means of telecommunication, provided that the requesting party is prepared, upon request, to produce at any time a written record of such communication and the original. However, each party may, at any time, by a declaration addressed to the Secretary-General of the Council of Europe, indicate the conditions in which it is ready to accept and execute requests received electronically or by any other means of communication. 2. Subject to the provisions of paragraph 3 of this article, translations of the requests or supporting documents shall not be required. 3. At the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, any state or the European Community may communicate to the Secretary-General of the Council of Europe a declaration that it reserves the right to require that requests made to it and documents supporting such requests be accompanied by a translation into its own language or into one of the official languages of the Council of Europe or into such one of these languages as it shall indicate. It may on that occasion declare its readiness to accept translations in any other language as it may specify. The other parties may apply the reciprocity rule. Article 36, Legalization. Documents transmitted in application of this chapter shall be exempt from all legalization formalities. Article 37, Content of Request. 1. Any request for cooperation under this chapter shall specify a. The authority making the request and the authority carrying out the investigations or proceedings. b. The object of and the reason for the request. c. The matters, including the relevant facts, such as date, place and circumstances of the offense, to which the investigations or proceedings relate, except in the case of a request for notification. d. Insofar as the cooperation involves coercive action. I. The text of the statutory provisions or, where this is not possible, a statement of the relevant law applicable and 2. An indication that the measure sought or any other measures having similar effects could be taken in the territory of the requesting party under its own law. e. Where necessary and insofar as possible. I. Details of the person or persons concerned, including name, date and place of birth, nationality and location, and, in the case of a legal person, its seat and 2. The property in relation to which cooperation is sought, its location, its connection with the person or persons concerned, any connection with the offense, as well as any available information about other persons, interests in the property and f. Any particular procedure the requesting party wishes to be followed. 2. A request for provisional measures under Section 3 in relation to seizure of property on which a confiscation order consisting in the requirement to pay a sum of money may be realized shall also indicate a maximum amount for which recovery is sought in that property. 3. In addition to the indications mentioned in paragraph 1, any request under Section 4 shall contain a. In the case of Article 23, paragraph 1, a. A certified true copy of the confiscation order made by the court in the requesting party and a statement of the grounds on the basis of which the order was made, if they are not indicated in the order itself. 2. An attestation by the competent authority of the requesting party that the confiscation order is enforceable and not subject to ordinary means of appeal. 3. Information as to the extent to which the enforcement of the order is requested and 4. Information as to the necessity of taking any provisional measures. b. In the case of Article 23, Paragraph 1, b. A statement of the facts relied upon by the requesting party sufficient to enable the requested party to seek the order under its domestic law. c. When third parties have had the opportunity to claim rights, documents demonstrating that this has been the case. Article 38, Defective Requests, 1. If a request does not comply with the provisions of this chapter or the information supplied is not sufficient to enable the requested party to deal with the request, that party may ask the requesting party to amend the request or to complete it with additional information. 2. The requested party may set a time limit for the receipt of such amendments or information. 3. Pending receipt of the requested amendments or information in relation to a request under Section 4 of this chapter, the requested party may take any of the measures referred to in Sections 2 or 3 of this chapter. Article 39, Plurality of Requests, 1. Where the requested party receives more than one request under Sections 3 or 4 of this chapter in respect of the same person or property, the plurality of requests shall not prevent the party from dealing with the requests involving the taking of provisional measures. 2. In the case of plurality of requests under Section 4 of this chapter, the requested party shall consider consulting the requesting parties. Article 40, Obligation to give reasons. The requested party shall give reasons for any decision to refuse, postpone or make conditional any cooperation under this chapter. Article 41, Information, 1. The requested party shall promptly inform the requesting party of a. The action initiated on a request under this chapter, b. The final result of the action carried out on the basis of the request, c. A decision to refuse, postpone or make conditional, in whole or in part, any cooperation under this chapter, d. Any circumstances which render impossible the carrying out of the action sought or are likely to delay it significantly, and e. In the event of provisional measures taken pursuant to a request under Sections 2 or 3 of this chapter, such provisions of its domestic law as would automatically lead to the lifting of the provisional measure. 2. The requesting party shall promptly inform the requested party of a. Any review, decision or any other fact by reason of which the confiscation order ceases to be wholly or partially enforceable, and b. Any development, factual or legal, by reason of which any action under this chapter is no longer justified. 3. Where a party, on the basis of the same confiscation order, requests confiscation in more than one party, it shall inform all parties which are affected by an enforcement of the order about the request. Article 42, Restriction of Use, 1. The requested party may make the execution of a request dependent on the condition that the information or evidence obtained will not, without its prior consent, be used or transmitted by the authorities of the requesting party for investigations or proceedings other than those specified in the request. 2. Each state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, by declaration addressed to the Secretary-General of the Council of Europe, declare that, without its prior consent, information or evidence provided by it under this chapter may not be used or transmitted by the authorities of the requesting party in investigations or proceedings other than those specified in the request. Article 43, Confidentiality, 1. The requesting party may require that the requested party keep confidential the facts and substance of the request, except to the extent necessary to execute the request. If the requested party cannot comply with the requirement of confidentiality, it shall promptly inform the requesting party. 2. The requesting party shall, if not contrary to basic principles of its national law and if so requested, keep confidential any evidence and information provided by the requested party, except to the extent that its disclosure is necessary for the investigations or proceedings described in the request. 3. Subject to the provisions of its domestic law, a party which has received spontaneous information under Article 20 shall comply with any requirement of confidentiality as required by the party which supplies the information. If the other party cannot comply with such requirement, it shall promptly inform the transmitting party. Article 44, Costs. The ordinary costs of complying with a request shall be borne by the requested party. Where costs of a substantial or extraordinary nature are necessary to comply with a request, the parties shall consult in order to agree the conditions on which the request is to be executed and how the costs shall be borne. Article 45, Damages. 1. When legal action on liability for damages resulting from an act or omission in relation to cooperation under this chapter has been initiated by a person, the parties concerned shall consider consulting each other, where appropriate, to determine how to apportion any sum of damages due. 2. A party which has become subject of a litigation for damages shall endeavor to inform the other party of such litigation if that party might have an interest in the case. Chapter 5. Cooperation between FUs. Article 46. Cooperation between FUs. 1. Parties shall ensure that FUs, as defined in this convention, shall cooperate for the purpose of combating money laundering, to assemble and analyze, or, if appropriate, investigate within the FU relevant information on any fact which might be an indication of money laundering in accordance with their national powers. 2. For the purposes of paragraph 1, each party shall ensure that FUs exchange, spontaneously or on request and either in accordance with this convention or in accordance with existing or future memoranda of understanding compatible with this convention, any accessible information that may be relevant to the processing or analysis of information or, if appropriate, to investigation by the FU regarding financial transactions related to money laundering and the natural or legal persons involved. 3. Each party shall ensure that the performance of the functions of the FUs under this article shall not be affected by their internal status, regardless of whether they are administrative, law enforcement or judicial authorities. 4. Each request made under this article shall be accompanied by a brief statement of the relevant facts known to the requesting FU. The FU shall specify in the request how the information sought will be used. 5. When a request is made in accordance with this article, the requested FU shall provide all relevant information, including accessible financial information and requested law enforcement data, sought in the request, without the need for a formal letter of request under applicable conventions or agreements between the parties. 6. An FU may refuse to divulge information which could lead to impairment of a criminal investigation being conducted in the requested party or, in exceptional circumstances, where divulging the information would be clearly disproportionate to the legitimate interests of a natural or legal person or the party concerned or would otherwise not be in accordance with fundamental principles of national law of the requested party. Any such refusal shall be appropriately explained to the FU requesting the information. 7. Information or documents obtained under this article shall only be used for the purposes laid down in paragraph 1. Information supplied by a counterpart FU shall not be disseminated to a third party, nor be used by the receiving FU for purposes other than analysis, without prior consent of the supplying FU. 8. When transmitting information or documents pursuant to this article, the transmitting FU may impose restrictions and conditions on the use of information for purposes other than those stipulated in paragraph 7. The receiving FU shall comply with any such restrictions and conditions. 9. Where a party wishes to use transmitted information or documents for criminal investigations or prosecutions for the purposes laid down in paragraph 7, The transmitting FOO may not refuse its consent to such use unless it does so on the basis of restrictions under its national law or conditions referred to in paragraph 6. Any refusal to grant consent shall be appropriately explained. 10. FOOs shall undertake all necessary measures, including security measures, to ensure that information submitted under this article is not accessible by any other authorities, agencies or departments. 11. The information submitted shall be protected, in conformity with the Council of Europe Convention of 28 January 1981 for the protection of individuals with regard to automatic processing of personal data, ETS number 108, and taking account of recommendation number R. 8715 of 15 September 1987 of the Committee of Ministers of the Council of Europe regulating the use of personal data in the police sector, by at least the same rules of confidentiality and protection of personal data as those that apply under the national legislation applicable to the requesting FOO. 12. The transmitting FOO may make reasonable inquiries as to the use made of information provided, and the receiving FOO shall, whenever practicable, provide such feedback. 13. Parties shall indicate the unit which is an FOO within the meaning of this article. Article 47, International Cooperation for Postponement of Suspicious Transactions. 1. Each party shall adopt such legislative or other measures as may be necessary to permit urgent action to be initiated by a FOO, at the request of a foreign FOO, to suspend or withhold consent to a transaction going ahead for such periods and depending on the same conditions as apply in its domestic law in respect of the postponement of transactions. 2. The action referred to in paragraph 1 shall be taken where the requested FOO is satisfied, upon justification by the requesting FOO, that a. The transaction is related to money laundering, and b. The transaction would have been suspended, or consent to the transaction going ahead would have been withheld, if the transaction had been the subject of a domestic suspicious transaction report. Chapter 6. Monitoring Mechanism and Settlement of Disputes. Article 48, Monitoring Mechanism and Settlement of Disputes. 1. The Conference of the Parties, COP, shall be responsible for following the implementation of the Convention. The COP, A, shall monitor the proper implementation of the Convention by the parties, B, shall, at the request of a party, express an opinion on any question concerning the interpretation and application of the Convention. 2. The COP shall carry out the functions under paragraph 1a, above by using any available select committee of experts on the evaluation of anti-money laundering measures, Moneyval, public summaries, for Moneyval countries, and any available FATF public summaries, for FATF countries, supplemented by periodic self-assessment questionnaires, as appropriate. The monitoring procedure will deal with areas covered by this convention only in respect of those areas which are not covered by other relevant international standards on which mutual evaluations are carried out by the FATF and Moneyval. 3. If the COP concludes that it requires further information in the discharge of its functions, it shall liaise with the party concerned, taking advantage, if so required by the COP, of the procedure and mechanism of Moneyval. The party concerned shall then report back to the COP. The COP shall on this basis decide whether or not to carry out a more in-depth assessment of the position of the party concerned. This may, but need not necessarily, involve a country visit by an evaluation team. 4. In case of a dispute between parties as to the interpretation or application of the Convention, they shall seek a settlement of the dispute through negotiation or any other peaceful means of their choice, including submission of the dispute to the COP, to an arbitral tribunal whose decisions shall be binding upon the parties, or to the International Court of Justice, as agreed upon by the parties concerned. 5. The COP shall adopt its own rules of procedure. 6. The Secretary-General of the Council of Europe shall convene the COP not later than 1 year following the entry into force of this convention. Thereafter, regular meetings of the COP shall be held in accordance with the rules of procedure adopted by the COP. Chapter 7. Final Provisions. Article 49, Signature and Entry into Force. 1. The Convention shall be open for signature by the Member States of the Council of Europe, the European Community and non-member states which have participated in its elaboration. Such states or the European Community may express their consent to be bound by a. Signature without reservation as to ratification, acceptance or approval, or b. Signature subject to ratification, acceptance or approval, followed by ratification, acceptance or approval. 2. Instruments of ratification, acceptance or approval shall be deposited with the Secretary-General of the Council of Europe. 3. This convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date on which 6 signatories, of which at least 4 are member states of the Council of Europe, have expressed their consent to be bound by the convention in accordance with the provisions of paragraph 1. 4. In respect of any signatory which subsequently expresses its consent to be bound by it, the convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date of the expression of its consent to be bound by the convention in accordance with the provisions of paragraph 1. 5. No party to the 1990 convention may ratify, accept or approve this convention without considering itself bound by at least the provisions corresponding to the provisions of the 1990 convention to which it is bound. 6. As from its entry into force, parties to this convention, which are at the same time parties to the 1990 convention, a. shall apply the provisions of this convention in their mutual relationships, b. shall continue to apply the provisions of the 1990 convention in their relations with other parties to the said convention, but not to the present convention. Article 50, Accession to the Convention. 1. After the entry into force of this convention, the Committee of Ministers of the Council of Europe, after consulting the parties to the convention, may invite any state not a member of the Council and not having participated in its elaboration to accede to this convention, by a decision taken by the majority provided for in Article 20, d. of the Statute of the Council of Europe and by the unanimous vote of the representatives of the parties entitled to sit on the committee. 2. In respect of any acceding state, the convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date of deposit of the instrument of accession with the Secretary-General of the Council of Europe. Article 51, Territorial Application. 1. Any state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, specify the territory or territories to which the convention shall apply. 2. Any party may, at any later date, by a declaration addressed to the Secretary-General of the Council of Europe, extend the application of the convention to any other territory specified in the declaration. In respect of such territory the convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date of receipt of such declaration by the Secretary-General. 3. Any declaration made under the 2 preceding paragraphs may, in respect of any territory specified in such declaration, be withdrawn by a notification addressed to the Secretary-General. The withdrawal shall become effective on the first day of the month following the expiration of a period of 3 months after the date of receipt of such notification by the Secretary-General. Article 52, Relationship to other conventions and agreements. 1. This convention does not affect the rights and undertakings of parties derived from international multilateral instruments concerning special matters. 2. The parties to this convention may conclude bilateral or multilateral agreements with one another on the matters dealt with in this convention, for the purposes of supplementing or strengthening its provisions or facilitating the application of the principles embodied in it. 3. If two or more parties have already concluded an agreement or treaty in respect of a subject which is dealt with in this convention or otherwise have established their relations in respect of that subject, they shall be entitled to apply that agreement or treaty or to regulate these relations accordingly, in lieu of the convention, if it facilitates international cooperation. 4. Parties which are members of the European Union shall, in their mutual relations, apply Community and European Union rules insofar as there are Community or European Union rules governing the particular subject concerned and applicable to the specific case, without prejudice to the object and purpose of the present convention and without prejudice to its full application with other parties. Article 53, Declarations and Reservations. 1. Any state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, make one or more of the declarations provided for in Article 3, Paragraph 2, Article 9, Paragraph 4, Article 17, Paragraph 5, Article 24, Paragraph 3, Article 31, Paragraph 2, Article 35, Paragraphs 1 and 3 and Article 42, Paragraph 2. 2. Any state or the European Community may also, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, by a declaration addressed to the Secretary-General, reserve its right not to apply, in part or in whole, the provisions of Article 7, Paragraph 2, Subparagraph C, Article 9, Paragraph 6, Article 46, Paragraph 5 and Article 47. 3. Any state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, declare the manner in which it intends to apply Articles 17 and 19 of this Convention, particularly taking into account applicable international agreements in the field of international cooperation in criminal matters. It shall notify any changes in this information to the Secretary-General of the Council of Europe. 4. Any state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, declare a. that it will not apply Article 3, Paragraph 4 of this Convention or b. that it will apply Article 3, Paragraph 4 of this Convention only partly or c. the manner in which it intends to apply Article 3, Paragraph 4 of this Convention. It shall notify any changes in this information to the Secretary-General of the Council of Europe. 5. No other reservation may be made. 6. Any party which has made a reservation under this article may wholly or partly withdraw it by means of a notification addressed to the Secretary-General of the Council of Europe. The withdrawal shall take effect on the date of receipt of such notification by the Secretary-General. 7. A party which has made a reservation in respect of a provision of the Convention may not claim the application of that provision by any other party. It may, however, if its reservation is partial or conditional, claim the application of that provision insofar as it has itself accepted it. Article 54, Amendments. 1. Amendments to the Convention may be proposed by any party, and shall be communicated by the Secretary-General of the Council of Europe to the Member States of the Council of Europe, to the European Community and to every non-member state which has acceded to or has been invited to accede to this Convention in accordance with the provisions of Article 50. 2. Any amendment proposed by a party shall be communicated to the European Committee on Crime Problems, CDPC, which shall submit to the Committee of Ministers its opinion on that proposed amendment. 3. the Committee of Ministers shall consider the proposed amendment and the opinion submitted by the CDPC and may adopt the amendment by the majority provided for in Article 20(d) of the Statute of the Council of Europe. 4. The text of any amendment adopted by the Committee of Ministers in accordance with paragraph 3 of this article shall be forwarded to the parties for acceptance. 5. Any amendment adopted in accordance with paragraph 3 of this article shall come into force on the 30th day after all parties have informed the Secretary-General of their acceptance thereof. 6. In order to update the categories of offences contained in the appendix, as well as amend Article 13, amendments may be proposed by any party or by the Committee of Ministers. They shall be communicated by the Secretary-General of the Council of Europe to the parties. 7. After having consulted the parties which are not members of the Council of Europe and, if necessary, the CDPC, the Committee of Ministers may adopt an amendment proposed in accordance with paragraph 6 by the majority provided for in Article 20(d) of the Statute of the Council of Europe. The amendment shall enter into force following the expiry of a period of 1 year after the date on which it has been forwarded to the parties. During this period, any party may notify the Secretary-General of any objection to the entry into force of the amendment in its respect. 8. If 1/3 of the parties notifies the Secretary-General of an objection to the entry into force of the amendment shall not enter into force. 9. If less than 1/3 of the parties notifies an objection, the amendment shall enter into force for those parties which have not notified an objection. 10. Once an amendment has entered into force in accordance with paragraphs 6 to 9 of this article and a party has notified an objection to it, this amendment shall come into force in respect of the party concerned on the first day of the month following the date on which it has notified the Secretary-General of the Council of Europe of its acceptance. A party which has made an objection may withdraw it at any time by notifying it to the Secretary-General of the Council of Europe. 11. If an amendment has been adopted by the Committee of Ministers, a state or the European Community may not express their consent to be bound by the Convention, without accepting at the same time the amendment. Article 55, Denunciation, 1. Any party may, at any time, denounce the Convention by means of a notification addressed to the Secretary-General of the Council of Europe. 2. Such denunciation shall become effective on the first day of the month following the expiration of a period of 3 months after the date of receipt of the notification by the Secretary-General. 3. The present Convention shall, however, continue to apply to the enforcement under Article 23 of confiscation for which a request has been made in conformity with the provisions of the Convention before the date on which such a denunciation takes effect. Article 56. Notifications. The Secretary-General of the Council of Europe shall notify the Member States of the Council of Europe, the European Community, the non-member states which have participated in the elaboration of the Convention, any state invited to accede to it and any other party to the Convention of a. Any signature, b. the deposit of any instrument of ratification, acceptance, approval or accession, c. any date of entry into force of the Convention in accordance with Articles 49 and 50, d. any declaration or reservation made under Article 53, e. any other act, notification or communication relating to the Convention, in witness whereof the undersigned, being duly authorized thereto, have signed this Convention. Done at Warsaw, this 16th day of May 2005, in English and in French, both texts being equally authentic, in a single copy which shall be deposited in the archives of the Council of Europe. The Secretary-General of the Council of Europe shall transmit certified copies to each member state of the Council of Europe, to the European Community, to the non-member states which have participated in the elaboration of the Convention and to any state invited to accede to it. Appendix A. Participation in an organized criminal group and racketeering. B. Terrorism, including financing of terrorism. C. Trafficking in human beings and migrant smuggling. D. Sexual exploitation, including sexual exploitation of children. E. Illicit trafficking in narcotic drugs and psychotropic substances. F. Illicit arms trafficking. G. Illicit trafficking in stolen and other goods. H. Corruption and bribery. I. Fraud. J. Counterfeiting currency. K. Counterfeiting and piracy of products. L. Environmental crime. M. Murder, grievous bodily injury. N. Kidnapping, illegal restraint and hostage-taking. O. Robbery or theft. P. Smuggling. Q. Extortion. R. Forgery. S. Piracy and T. Insider trading and market manipulation.